regarding the matter before the commission. Any person who wishes to speak at the hearing will be sworn in and may be subject to cross-examination. The applicant and county staff may cross-examine witnesses. Any other persons attending the hearing may submit cross-examination questions, including follow-up questions, to the chair, who will conduct the examination. The scope of cross-examination is limited to the facts alleged by the witness in relation to the application. Public comment is encouraged, and all relevant information should be presented to the commission in order that a fair and appropriate decision can be made. Proof of publication.
A motion to receive and file.
I'll second the motion.
All in favor?
Aye.
Aye. Any opposed? Motion passes. Swearing in.
Will all those wanting to testify on today's items please rise? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Approval of previous minutes.
I'll motion.
Approve the October minutes.
Do we have a second?
Second.
Thank you. All in favor?
Aye.
Any opposed? Okay. Amendments to the agenda.
Good morning. So we have a couple amendments to the agenda on the add delete sheet. The first is moving the American Heritage School, item number 1, from the consent agenda to the postponement agenda, with a motion to postpone to the December 4th Zoning Commission hearing. Because the item had been advertised, we were not able, and because of the request coming in on Tuesday, it missed the deadline for an administrative postponement. However, staff is really supporting the postponement because the residents are mostly not here. There are some residents here, and they can speak to the postponement under public comment when we get to the postponement part of the agenda.
Just to the postponement, though.
Correct.
Okay.
They'll be allowed to speak to the broader issues next month if it's postponed.
Okay.
The next item on add delete is also for item 1 to modify the development order amendment to make some changes shown in the add, delete, and strike out and underline to conditions of approval. On the regular agenda, item 2 and item 3, green market and reasonable accommodation, we have some changes to the motions. This is something to keep in mind when we hear those items later. So that's everything. If you'd like to take a motion and vote to approve the agenda, then we would move into the postponement agenda.
To adopt the agenda.
Second the motion.
All in favor?
Aye.
Any opposed? Motion passes. All right. Any conflicts or recusals, starting on my left?
No conflicts, none.
No conflicts.
None.
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 I have none.
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 Okay. That's in the agenda.
So now we'll do the postponement, and if there's any disclosures on item 1, it's probably a good idea to have those before we take a vote on postponement.
Okay. Any disclosures on item 1?
None.
None.
I spoke to Scott Bachman, the applicant's representative, multiple residents of Lakes of Delray and multiple residents of Kings Point, and I've received several emails.
None.
I have none.
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 Okay. On the we do have one card on this topic, and
So I'd like to call Lisa DeTaylor.
Hi, thank you.
You need to come up to the podium and state your name and address, please.
Hi, thank you.
You'll have 3 minutes, and as we said, you'll have to speak only to the postponement.
Thank you. My name is Lisa D. Taylor. I live at 6161 Via Venetia North, which is in the Misner's Preserve community. My backyard is adjacent to the back of the property in question. First of all, I want to commend the planner, Mr. Zamora, was extremely gracious in providing me with information. I realize that I'm only allowed to address the issue of the postponement, and I want you to know that I object because I'm here. I have a position on it. I have information I'd like to share with you. It's extremely inconvenient. I actually have business travel next month, and I can't come back. next month to share it. And, you know, I understand that the applicant is asking for an adjournment, but it wastes my time and it's extremely discourteous. Thank you.
We understand, thank you.
And I wish, you know, and I would appreciate, you know, and if I had the opportunity to give you 1 minute of what my concern was, that would be, well, solve it, but I realize I'm not allowed to. But at least my objection to this is on the public record.
It is, thank you. Okay, we're then moving on to the,
Mr. Chairman, the person who spoke, she can always, if she's not available to attend the next hearing, she can submit her position to the county and let us know. We can be right into the record.
and we do have her comments on a comment card, and if she wants to expound more on that, you can submit something.
Well, I would like to, certainly. Thank you.
Okay,
This item would be on the December 10th Board of County Commissioners hearing, so she can attend that and submit documents for that as well.
okay. Okay, so moving on to the,
Well,
We need a
yeah,
motion.
We need a vote.
Motion and a
oh,
vote.
yeah, a
Motion to
to,
postpone item 1 to the December 4th zoning commission hearing.
Second.
all in favor?
Aye.
Any opposed? No. Motion passes. Thank you. On
Next.
the consent agenda?
That's the end of the consent agenda. And next on the regular agenda, we have Green Market, item 2. We have a presentation from Alex for us this morning.
Can I just interrupt? I'm sorry. I'm here, just for the record. Thank you, sorry.
Thank you.
For the record, Susan Kennedy arrived. There's Alex.
Good morning. For the record, Alex Byray, Senior Site Planner of the Zoning Division. These revisions to the Palm Beach County Unified Land Development Code propose to merge the commercial use type of green market, also known as the permanent green market, with the temporary use type of green market. The consolidated use will allow a temporary use approval in a manner similar to a special permit to allow weekend and federal holiday operations from 6 months to 12 months per year. Should be noted, apart from the approval process and duration of months per year, permanent green markets are differentiated from temporary green markets by being allowed to operate on any 3 days of the week, regardless of weekends or holidays. This allowance is now proposed to be carried forward in the merged uses, which is reviewed by the Development Review Officer, or DRO, subject to site plan approval. Furthermore, a permanent green market accessory to a community vegetable garden operated by a neighborhood organization in the Westgate Community Redevelopment Area Overlay, or countywide community revitalization team areas, which is exclusively a DRO approval, is proposed to be revised to be allowed as a temporary use approval. At the October 23, 2025 Board of County Commissioners zoning hearing, request for permission to advertise for final adoption was approved by a vote of 5-0. So essentially, these proposed revisions further implement the Board of County Commissioners' direction to streamline the code and provide more flexibility. In this case, green markets will be able to operate at a longer duration than 6 months through a more appropriate approval process based on what is inherently a temporary use for areas underutilized on weekends, such as commercial office parks. Staff therefore recommends to the Zoning Commission approval of the requested ULDC revisions, and to the Zoning Commission serving as the Land Development Regulation Commission that the proposed revisions are found to be consistent with the Palm Beach County Comprehensive Plan. That concludes my presentation, and we will be happy to answer any questions. Thank you.
Okay, any questions from the commission?
I have a couple questions. Okay, so I understand the purpose is to merge these two provisions, one with regards to commercial green markets and one with regards to temporary green markets?
There's the commercial green market, which is a permanent use, meaning that the approval is shown on the site plan and it operates within the confines of the code year-round, not necessarily 24/7, Well, a temporary green market is a temporary use approval that's currently valid up to 6 months or how it's approved by the special permit, and then it's renewed annually.
Okay.
If I may elaborate on that a little bit. So once upon a time, there was no such thing as a temporary use. It was a special permit approval. And there are certain uses that still reside in the code as a special permit approval, such as doggy dining that was approved a couple years ago and billboards. With the use regulation project in 2018, they created something called temporary uses. And the difference between a permanent green market and a temporary green market is the difference between 6 months or 12 months. But in either case, it's the same exact use of the property. It's going into a commercial plaza, or it's going somewhere that already exists and already has a site plan approval. A green market in our code is not something that requires the construction of buildings, the laying down of asphalt, because that's already there from the other approval. So what we're doing is we had an applicant come in and they wanted to operate in a commercial office parking lot, but because of the way the code is structured, they were having to do all of these site plan modifications at, thousands and thousands of dollars just to put little notes on the commercial office parking lot site plan that a green market was there. And the review was absolutely burdensome. And when we examined the whole process, ideally, if I had had the time, I would have reestablished the special permit process for the temporary uses in the code. There's a whole variety of these uses. There's produce stand, real estate sales office, all of these type of uses that exist in another approval's infrastructure. But I didn't have the time to do that, so we decided just to consolidate the two as the temporary use permit.
So my two questions really were the elimination of the word permanent and temporary, and just the significance of that is what I was trying to understand.
How the code is structured, the approval processes can be public hearing, and that's and they're Class A public hearing items go to the Board of County Commissioners. Class B public hearing items go to the Zoning Commission. The DRO approvals, which are approved by the Development Officer, which is the zoning director, following coordination with the 17 DRO review agencies. There's zoning confirmation letters are administratively approved, and temporary uses are administratively approved. So the name temporary just applies to the list of uses in the code for which they go through the administrative review process. So I wish I had the longer presentation that we gave to the Board of County Commissioners that listed out all of those uses. But so essentially, it's really a special permit. Well,
that was simply my question, just the significance of eliminating the reference from permanent to temporary, and what the significance was that.
I'm sorry, to expand on that, when you think about it, a Class B use, a Class A use, a DRO approval, they run with the land. If we approve a out parcel for a Taco Bell, it could change to a Chick-fil-A, and it will run with the land. The temporary uses or special permits, they don't necessarily run with the land. So we're not, when these applicants come in, whether or not it was in the permanent part of the code or the temporary part, the use of the green market is not a use by the landowner. It's a relationship between the green market operator and the landowner. So if what we're setting up is like the temporary use approvals, if that relationship is severed, then the temporary use stops. It doesn't run with the land. But that's like all of the type of special permit uses. They don't run with the land. It's an agreement by the property owner of the office park or whatever that wants to lease out on weekends and holidays a green market on their property. So that's I hope that provides some
No, it
additional
does.
background.
That was my fundamental question. The one other question I had was, in the proposed language, it states, it defines what a green market is, and it eliminates a temporary, so it says that's eliminate a gathering of vendors, and then apparently it used to say, or it currently says primarily for the purposes of selling fresh, unprocessed fruit, vegetables, flowers, etc., and it eliminates the word primarily, so it's basically just for the, is there any significance to that?
We took the two definitions and we don't know why they were different, and we merged them together. And
Okay.
Yeah, Jerome Artie with the zoning division. So for the permanent right now, it didn't have primarily. It just had a list of selling fresh, unprocessed fruit, vegetables, flowers, and consumable items such as coffee, bread, and prepared food. But it's basically the same thing. So we just took out the primarily, so it applies the same as how it applies for the permanent.
Because I just understand at the green market, sometimes they sell items
Yeah.
beyond that, and
Right,
I was trying to understand the
And
significance.
if we were to keep the word primarily, it might have been construed by state law as being more restrictive.
Okay, fair enough. Thank you.
Okay. Any other questions? We're ready for a motion on item 2.
Motion to approve item, of item 2A.
Have a second?
Second the motion.
All in favor?
Aye.
Aye. Any opposed? No.
Val, the second part doesn't need to be approved, right? You just said,
Does it need a motion on the second
need a
part?
motion?
Yes,
Yeah.
we do. Yeah.
okay, so we've already discussed this. The zoning commission serving as a land development regulation commission pursuant to 163.3194, F, period, S, period, approves staff recommendations of item 2B.
Second.
We have a motion and a second. All in favor?
Aye.
Aye.
Any opposed? Okay, that motion passes. Item 3, then.
next item number 3 will be discussed by Jerome Artie.
Morning, Jerome Artie again. So this one is the reasonable accommodation revisions to the code, and this is specific to certified recovery residences. So in this year's 2025 legislative session, the governor approved changes to Florida Statute 397 to require that local governments include a reasonable accommodation process for certified recovery residences, specifically requiring an expedited review of applications. We currently have in our Unified Land Development Code a reasonable accommodation process through the Type 2 waiver, and that is approved by the BCC. And this was basically, kind of revised for these reasonable accommodations, specifically again for the certified recovery residences. The statute also requires revocation of reasonable accommodation approvals for these certified recovery residences, and staff work very closely with the county attorney's office to ensure consistency with the statute. At the October 23rd, 2025 BCC hearing, the BCC approved request for permission to advertise by a vote of 5-0. Staff recommends approval, and the motions today are a recommendation of approval for item 3A and recommendation that the Zoning Commission, serving as the Land Development Regulation Commission, recommends that the proposed lease revision is found to be consistent with the comprehensive plan.
Any questions?
I have a couple questions. Does staff work closely with the county attorney's office, but did you run this by the state attorney's office, like Alan Johnson? Because he does chair the state attorney's addiction recovery task force, which I serve on.
Yeah, so we worked with, as I said, we worked with the county attorneys. We didn't really check with, maybe Scott Stone checked with him, but zoning staff did not. So this is basically, we limited our review, our proposed language to make it just so that it's consistent with the statute. We already had some, as I said, we already had some reasonable accommodation for Type 2 waiver, and we simply just added the time frame and the revocation, and that was the only thing that we needed to be consistent with the statute.
Okay, so Scott would know if you spoke with the state attorney's
Scott, yes,
office
Scott
and
would know,
all.
but he's not.
Okay, well, it's I'm sure that I guess they must know about it. 'Cause we work on the Florida statute every year, making these revisions. Okay, thank you. I'll recommend approval of the proposed ULDC revision,
Second.
item 3A.
Item 3A, motion and a second. All in favor?
Aye.
Any opposed?
And the Zoning Commission, serving as the Land Development Regulation Commission pursuant to 163.3194 Florida statute, recommends the proposed ULDC revision is found to be consistent with the comprehensive plan.
Second.
All in favor?
Aye.
Aye.
Any opposed? Motion passes. Okay, any comments? We've got a request from Lisa. Go ahead.
Yes. Thank you all. It's been a pleasure serving with you. I've recently taken a position with the Cooperative Extension Service as the Agricultural Development Coordinator. I look forward to working with you in the future regarding agricultural items and agricultural projects or changes to the ULDC. You have an absolutely fantastic zoning team before you every month. Wendy Hernandez will be serving as interim zoning director. You have principal planners behind the scenes, such as Monica Cantor and Melissa Matos, that you don't see frequently, but they're making things work back there. And Jerome Adi, principal planner, and an amazing short-handed staff. We are down 2 principal planners and about 25%. Yet we get the packet out every single month, and we bring you just so much talent in zoning, and they're just, I can't say enough good words about them. So again, it's been a pleasure. I'll see you again if you go to Mounts Botanical Garden. That's where I'll be working. And on agricultural items, maybe working with Dr. Vinacore in the Ag Reserve a little bit.
Yeah.
So I just wanted to say those words. Thank you.
I have a
Thank you.
question.
Terrific,
yes.
Lisa.
I have a question. What's the relationship with Ron Rice?
I'll work for him.
For him. Okay,
Art
so.
Kirsten, do you remember Art Kirsten?
Oh, Arthur Kirsten. Arthur Kirsten, of course, who can. Yes, I was also president of the Rare Fruit Council for a few years. So Arthur, yeah, he was great, and he worked. So you're taking his position, so you'll be working out in the EAA a lot.
Yes. EAA, Ag Reserve, anywhere there's agriculture, hopefully working with PZB on some agritourism guidelines, which is always something that comes up. The ULDC agricultural language is quite out of date. And for the past 4 years in this position, I've been kind of overriding it. And the time is probably here for us to revise a little bit, working in partnership with this board, Board of County Commissioners and zoning staff to bring it up to modern standards, because it's much more restrictive for agriculture than the statute. So we've had to, override it. And so hopefully we can fix some of those regs.
Lisa, we will miss you. You've made our job so much easier up here. We really appreciate all that you did.
Sure have.
Thank you.
Yeah.
You'll be missed.
Yes,
Thank
very
you.
much.
Thank you.
Thank you.
Thank
Wish
you so
luck.
much.
Congratulations.
Okay.
A motion to adjourn?
Second.
All in favor?
Aye.
Aye. We are adjourned.